Hello, it's Philip Taylor speaking from Richmond, Green Chambers in London. I'm looking at this lovely little book today, which I really enjoyed reading. It's come to us from Bloomsbury Professional Law, and it's on the law of contract. It's force majeure and frustration in commercial contracts. And I like this book. I've always really enjoyed teaching the doctrine of frustration of common law to students. I haven't really had many cases involving it because not that much comes up. The case law I deal with is a little bit more basic than that quite often. But this book by Ben Symons, with a contributor from Joseph Dalby, SC, Scottish Council, is a first-class book. Elizabeth was the lead writer on the book, and she gave the title of this review an excellent restatement of force majeure and frustration, pertinent to the post-COVID era. Commercial practitioners take note. And I think that's an important point to bear in mind, because we are now in post-COVID for the purposes, although there's still an awful lot of problems around, but we are trying to get back to where we are. And this book comes at the right time in the middle of the year, 2022. There's the book. It's a hardback. You can see the spine. There's not really very much on the spine. Then on the back you can see this blurb about the book there. Then you've got the little information about Bloomsbury and the online service that they offer, which is on the back there. They're all very modern, you know, very, very modern. But I'm glad, because we need to keep up to date, especially with what is happening at the moment. There is the index at the back. It's by paragraph numbering. It's not a big index at all, but it does cover. It says all references are to paragraph numbers. You'll see that at the back. Then you can see the last page. You can see some of the blurb there. There's a bit of footnoting. If we go into the book itself, I'll just take that out. There's the chapter 10 on frustration. You can see standard structure, introduction, paragraph numbering, and then you've got the cases, some of the cases that are actually referred to in the footnotes. Going to the front of it, there's the front page there. And after that, we get to that main front page. Nice little logo of Bloomsbury. Both people are from Ben and Joseph are from the 36 group. There's some blurb about Bloomsbury, then the preface. Do read the preface. It's worth reading because it sets out what this book is about. It's a new book. They're trying very hard to point out what has happened with force majeure in the last few years, because obviously we're talking of well over a century now of its effect. And of course you've got the classic cases of the past, the coronation cases from Edward VII's reign. There's the end of the actual. It's actually a preface. Then we've got the contents section. And you see the little notes going all the way through. There are 10 chapters in total, ending up with frustration at the end. Then you've got the cases. All the usual suspects are here, I hasten to add. So any of your favourites, you can always have a look. Table of statutes, not very many of them. Then we get into the book itself. Introduction to what force majeure really is, paragraph numbering, and then the term itself and how it's developed. Act of God, whatever you could, all sorts of different ways of deciding what you think it means. Force majeure in French literally means superior force. Could be act of God, could be all sorts of things, depending on your point of view, really, I suppose. But it's an intervening act, effectively. There we go. And then we run through and you see it's what I loved about this book is it's actually a short book, a few hundred pages, and it's easy to read. I found it incredibly easy to read. Mind you, that's probably because A, I like the subject, and B, it's not too difficult. Not when you consider some of the other areas of contract. Anyway, so what do we really say? It's an interesting book. Thorough, erudite and easy to read too, as I've just said. It covers an area of law about which not a lot has been written, largely due in the past years to the relative scarcity of case law in relation to both frustration and force majeure. As I said, it's lovely subject matter to teach, and it will get people's interest. And of course, as I've said, these words force majeure, which may not be that well known to people, it refers to a superior force such as floods, fires, storms, earthquakes and other acts of God which can frustrate the performance of a contract. And just think, when you're going at it, to the law of tort, acts of God in the law of tort as well. So you can see that's the general common law flavour of how things have developed over the centuries. And as the author Ben Symons points out, the recent COVID-19 pandemic triggered the issuance of a multitude of force majeure notices and initiated a great deal of interest in force majeure clauses. And naturally too, because you can take parallels when you have something that's a really unexpected, unwelcome event. It's bound to have a very substantial effect on the way we go about our business, and of course the pandemic certainly did that in spades. Interestingly, the book deals succinctly with the definitions of pandemic, epidemic, act of God, etc. Definitions which by their nature are by no means precise and therefore arguable, debatable and controversial. Also note the definitions, or often discussions as they are, of what is meant by other relevant terms such as riot, piracy, embargo, war and extensive military mobilisation. And with reference to recent tragic events, and we know where they are, the distinction between these latter two definitions is certainly debatable. That is, I'm talking specifically, of course, about Ukraine, I'm talking about Russian aggression, and I'm talking about war, not extensive military mobilisation, but a war. An act of military aggression by Russia against the Ukraine. There's no point in debating any other issue because that's what happened. So you can use the niceties, but in fact in this case, you see, when I'm talking about these distinctions, that's one of the problems. As barristers, we do tend to we go down to the very fine distinctions, but in reality, as judges point out to me often enough, just get on with it, tell the tale, and I'll decide what I think. And don't make it overcomplicated, that's another thing. Now, this book isn't overcomplicated, which is one of the reasons I like it. And it's important to note that we are reminded, of course, that force majeure clauses are more common in such industries as oil and gas. Keeps a little moment with Ukraine. Nuclear power and shipping, mostly of course litigated in the courts in England and Wales, in London, as most contracts specify that they are indeed subject to the law of England and Wales, whether or not the parties involved have any connection with this jurisdiction or not. Even so, says the author, England and Wales is the jurisdiction in which disputes in relation to force majeure clauses are more likely to arise, and in fact that's I think a very valid point. But also do bear in mind that the international jurisprudence from countries as diverse as Australia, Canada, Singapore and Hong Kong, all of course common law jurisdictions, in relation to force majeure are also examined, as are other key issues such as causation, always important of course in this day and age, notice, mitigation and of course much more. The coverage of the subject is nothing if not thorough, and for busy practitioners like myself the book is easily navigable thanks to the detailed table of contents at the front, the index, not a big one but a good one at the back, and the table of cases and statutes. Let me conclude by saying concerning Bloomsbury that for commercial practitioners and law students alike, and teachers such as myself when I was teaching, this eminently useful text from Bloomsbury provides carefully researched and authoritative coverage of both force majeure and frustration. They leave the frustration element to the last chapter, but the definition and application to commercial contracts is there nonetheless, and it's a most recent statement, as I understand it, concerning this subject area currently available. It's always useful, of course, to compare what we have here with what is in the established common law title, Chitty on Contracts. The date of publication is the 23rd of June 2022, and the law is as stated in December 2021. So it's been 6 months since the book has gone through, because I'm recording this in high summer. There is the book again, the spine and then the back, Just open it up in the middle. What have we got here? This is an introduction to causation. Now, I think causation is often very misunderstood. There we go, we've got it there. This is chapter 6, causation in relation to commercial contract. I think it's important to bear this in mind. Again, we've got quite a lot of relatively new case law, which is brought in here. You can see the actual paragraph numbering at the side, and you've got the case relevant case references, Supreme Court reference numbers there. But with some subjects like causation, it's always useful to read a book like this just to get an idea of where we are very recently with what the justices in the Supreme Court have to say about the matter. And of course, as I've indicated, to refresh one's memory about where we are, because it's quite possible that we may get some case law coming up arising from the COVID pandemic. It'll take some time to arrive, but there will be quite a lot of interesting disputes as a result. But in the meantime, I'd like to thank the author very much indeed, Ben Symons, and the contributor Joseph Dalby. Very grateful to you for writing such a nice book, and it's one I shall treasure. So I'll pat it. Thank you very much indeed to everyone. Bye-bye.